Hi, good afternoon, everyone. This is Rajiv S. Khanna for immigration.com, the law offices of Rajiv S. Khanna PC. Our bi-monthly or bi-weekly call, community conference call, where we try to answer your questions. As you would have heard when you first logged into the call, what the terms and conditions of this call are. We do the best we can to answer your questions, but this does not create an attorney-client relationship. I'm going to go over, as usual, first the questions I have marked as the frequently asked questions. Um, Once I'm done answering the frequently asked questions, I will, of course, open the floor to follow-ups on the frequently asked questions only. Once I'm done with those, then I will go over all the questions that have been posted one by one. And at the end of that questions answering session, I would then invite um, follow-up questions from people who have posted questions. And finally, at the end of the call, once we are done with the frequently asked questions as well as the posted questions, we'll take on new questions. We should be able to wrap it all up in 1 hour, no problem at all. Okay, so here we go. Let me get started with the questions that I have marked as frequently asked questions. Going to, let's see. Uh, it so happens that the question number 10 deals with an issue of the H4 EAD rule. As you folks know, um, there is a regulation pending. It has been pending for a long time. And we were expecting that in December, it will get finalized and be published. And H4 people whose spouses are at the I-140 stage would have the right to work with an EAD. So far, that is still pending. There is no news on that. A couple of weeks ago, or was it last week, USCIS has said that they are very close to finalizing that regulation. But knowing the government, I don't know what very close means. Could it be tomorrow? Maybe. Could it be 10 days from now? Maybe. Maybe. Could it be never? Who knows? Okay. So, but one thing I want you to distinguish is that there's a difference between the executive action of Obama and the pending regulation for H4 EAD. These are two different things. Okay. Maybe the difference is a difference without much distinction, but it's a difference nonetheless. Right now, we are waiting for the regulation that was pending to be published. That brings me to the question number 10 that I have marked as a frequently asked question from Teja Nai. He says, my wife and I are living in different states because of work. I have my I-140 approved. Wife is also on H-1B. Okay. So should we get the H-4 approval before the regulations come out, and then she can get her EAD and move to my city? If she applies for H-4, when can she quit the job? She can quit the job on the date USCIS receives her H-4 application. And if you do the H-4 application online, then she can quit the same day. So Teja says, I'm aware that no rule has yet been published, but what are your thoughts? Well, as I said in the beginning, I am concerned about when the H4 EAD rule will be published and whether it will actually go through at all. I mean, that's probably being ridiculously pessimistic. But I would still want you to wait and see what the rule looks like before you start making any changes in the work authorization. If you are okay with this, with the idea that your wife could end up not being able to work at all for many, many months, then okay, go ahead and apply for H4, have her move. But if you don't want to take that chance, then wait until the regulations become finalized. Then you can decide how you want to go. Okay. If you are on the phone, if you are on this call, Teja, press *5. Anybody who has any questions on H4 EAD rule, press *5. So we'll deal with all the issues related to H4 EAD right now. There's one raised hand. Press *5 if somebody else has a question on this issue only. Okay, two people with H4 EAD issue. All right. Let me start with the person who logged in first. Ma'am, go ahead. New York, go ahead. New York. Hello, New York. I can, if you
Hello?
talk, yeah, I can hear you.
Hello?
Yes, ma'am.
Hi. I have a question that can we file both concurrently? If the rule comes out, can we file H4 and EAD concurrently?
Um, my guess would be yes, and I'll tell you why.
Okay.
Because the closest equivalent to this rule is the rule of L2 EAD. Okay, when we do an L2 EAD, we file L2 change of status as well as EAD at the same time. So my guess is we don't right now we don't really know, but my guess is we should be able to file for H4 as well as EAD simultaneously.
Okay.
All right.
Okay, sure. Thank you so much.
You're welcome. Connecticut, go ahead, please. Connecticut.
Yeah, hi Rajiv. My wife just asked the question that I wanted to ask. So,
Oh,
as I
okay.
said, we are in two different states, so we just unmuted parallelly.
Okay, okay, no problem. So you're all set, huh?
Yeah, thank you very much.
You're welcome, sir. So two questions, two people's questions answered in one shot. Not bad. Let me go on to the next frequently asked question. I had received a couple of emails from some members of the community. So what I did was, instead of trying to answer them individually, I just put that all in the conference call today. So this is the last set of frequently asked questions. It's about the H1 quota. How does H1 quota work? And I think this is an issue that's important for many people. One of them is, I am on L1A. If I get H1B this April, is it mandatory to work on H1B from October 1st? Can I continue on L1A and then change to H1B whenever I like? And the answer is, it can be done. Sure. Here's how you do. When you apply for an H1, don't apply for a change of status. That's up to you. You can tell the employer and double check it. Make sure you talk with the lawyers. Just say, I want an H1 approval, but I do not want change of status. That way, you will have, come October 1st, you don't automatically get on to H1. You stay on L1. You can continue working on L1. And whenever you're ready, you can go outside, get visa stamping, and come back, or apply for change of status within USA to H1, which is like doing the H1 all over again, but you are not subject to the quota. So that's how you do it. Okay. The next question was about, when do I become exempt from H1 quota? This member of our community says, I had spoken to you on EP2 issues, EP1 issues. So I got my H1B in 2008, then extended until 2011. I've never used both of these to work in the US, though I have traveled a few times to US, but on B1. Well, it's a very odd situation. I think USCIS's interpretation of when you become exempt from the quota is incorrect. But this is their current thinking, at least as of last week. With them, you never know. They felt if you are outside USA and you get an H1B approval, never go for visa stamping. You are not exempt from the quota. So if you never get visa stamped, we don't consider you to be exempt. If you are in the United States and you get your H1 approval, but the employer who got the approval revokes your H1 before October 1st, you are not exempt from the quota. I think both these interpretations are incorrect. I would encourage you to try and take a chance and see if you can be considered to be quota exempt anyway. If I were you, I would certainly file a quota application in April just to preserve all my rights. And if it does not get selected in the lottery, file again and this time ask for quota exemption because of the reason that you have an H1 from before. Okay, that's all I have to say on these two issues. Now, anyone has any question related to quota exemption, H1 quota exemption, or how to change status to H1, etc., please press *5 on your phone. Any question only on H1 quota, press *5. Okay. Oh, there is one. All right. Illinois, go ahead, please. There's two questions. Illinois, go ahead.
Hello.
Yes, sir.
Yeah. So my question is, I have used my H1 for about less than 5 years, and then I came back to India, and I'm in India for about almost 3 years. Now, can I use the rest of my 6 years? So like 1 year, few months, or I need to apply for a fresh quota?
You have two choices. You are subject to something called, or you have the option of something called remainder option. What you can do is,
option.
yes, what you can do is, since you have been outside USA for more than 1 year, you are actually entitled to all 6 years of H1 again. Okay?
Again?
You are entitled to all your 6 years of H1 again. Okay?
Okay.
But if you decide to do that, you are subject to the quota. Okay? Your second option, which is the remainder option, is like this. If you have had an H1 in the last 6 years, which you have, and you've been outside USA for more than 1 year, you can choose to take whatever remains of your H1 and not be subject to the quota. So if you have 1 year and 6 months remaining on your H1, you can take that and not be subject to the quota.
Okay.
That's called
And
remainder
basically,
option.
to continue staying in US, I have to get the green card process started.
Exactly. So pretty much get the green card process started as quickly as possible.
Okay. And in that case, I do not get the extension of H1, right?
You do. You absolutely do.
I do. Okay.
Yes. You have the same rights available to you for extension as they are available to anybody who's just in the first year of their H1. So as far as extension rights are concerned, they are not disturbed by the remainder option.
Okay. And on the remainder option, I can apply anytime, right?
Within the 6 years of approval of your H1. So, you can, yes.
But not the 1st of April thing.
No, you're not, because you're not subject to the quota. You can apply anytime. You can apply today if you want.
Great. Thank you.
Oh, you're welcome. Good luck.
Thanks.
Okay. We have one more question on H1 quota. Texas, go ahead, please. I can hear you. Texas.
Hello. So this is I'm calling from Austin, Texas, and my nephew he filed H1B visa in 2010, and it got approved. And but his employer did not give his approved copy, so he was not able to actually go for the stamping. So he has that the H1B filing copy, which is I-129. So based on that I-129 copy, can he reapply for H1B visa without any quota, or he has to go for the quota again?
See, I discussed this issue just a minute ago, and the problem is USCIS's interpretation is that if you get an H1 approval, but then you don't get it stamped, you are still subject to the quota. If I were you, I would at least try, because I think their interpretation is incorrect. The law very clearly says if your H1 has been approved in the past 6 years, you are exempt from the quota. It says nothing about you having to apply for a visa. So in my opinion, it's worth a shot, but I'm also telling you what their current thinking is. Okay? So the practical advice I have for you is this. You can apply for a quota exemption H1 right now, and apply again on April 1st for under quota H1. Or you can wait and apply for under quota H1 on April 1st. If it goes through, great. If it doesn't go through and you don't win in the lottery, then try to apply for an H1 claiming quota exemption. Let's see how it goes. Okay.
Okay. So is there any specific document for the H1B exemption quota, any document numbers, specific document numbers?
For the H1 quota exemption, you need a copy of the I-129 approval receipt, the H1 approval receipt.
Okay.
I'm sorry, the H1 approval notice. If you don't have that, try with what you've got.
We have it.
If you have
No,
that,
I want 129 copy.
the approval, right? The approval of the 129?
No, not approval, sir. Just H1B filing copy, I-129.
Do you have a copy of the receipt at least?
Yeah, I have a copy of I-129, that initial filing of H1B,
Well,
but I don't have the H1B approval copy.
that may not be enough, but go ahead and try anyway. We have been able to get quota exemptions in similar cases with just the name of the employer and the name of the employee.
Okay.
All right. Good luck to you.
Thank you, sir. Thank you very much for.
You're welcome. Okay, folks, I'm done with the frequently asked questions. Now I'm going to go over all the posted questions, answer them all one by one. Then I will open the floor for questions on posted questions. Once we are done with the posted questions, then we'll start with new questions, okay? Somebody who's just walked into the conference, we'll start with them. First posted question is from V. Satish. He's got a 2-year MSc and a 3-year BSc. So he's got 5 years of college. Employer applied for PERM, got I-140 approved in EB3, then applied again for EB3 to another employer because they said, well, you don't have equivalent of 4 years of education. I'm not sure why they did that. They could have still applied under BS plus 5 years criterion. But okay, if they have not done it, your question is, now I have finished master's degree in USA. Can we start the PERM is under audit, the current PERM, can we start another PERM under EB2? And I think once you have responded to the audit, it's okay for you to withdraw that petition and start another case under EB2. I don't see any problem with that. Okay, so that's what I would do. Says, does the employer B have the right to apply for PERM under EB2 and withdraw the current PERM? Yes, but don't withdraw without first responding to the audit. It's a red flag. When there's an audit and people withdraw their case, it's not a good thing. So what I do in these cases is I respond to the audit and at the same time make a request to withdraw. Start your EB2 case. Do we need any experience after completion of MS for EB2? No. That's the difference between EB2 through master's degree and through bachelor's. When you try to get to EB2 through a bachelor's, you need 5 years of post-bachelor's experience. But for master's degree eligibility, the experience can be post or pre-bachelor's. It's no problem. Next question is from Glyn3845. Wife and kid are in H4 stamping done with this employer. Visa is expired. They're traveling to India. We have a valid H4 petition till 2018. Do they need to go for counselor interview? Hey, if they are eligible for the interview waiver, I'm sorry I don't have the requirements in front of me. Go over the requirements. If you have any doubt, send the consulate an email. They usually do respond to emails. So if they are eligible for the waiver, go for it, but they do have to apply for an H4 visa, of course. In DS 160, there's a question, which petition number should be provided? Because again, I think I would send this to the consulate. I don't know exactly what we do. I remember we figured this out a long time ago, but I don't remember exactly what we figured out. I don't recall what we are doing. I think there is a frequently asked question on this on the consular website. Take a look, send them an email. If you're not able to find this information, call back to in the next conference call, we can talk again. I'll find out the information for you. Has anyone ever filed an immigrant petition? Yes or no? You have your I-140 approved. Her name was not included in the label and the I-140. Well, when you file the I-140, were you not married? Because if you are married, you do put down her name in the I-140, and then the answer should be yes, because you have filed I-140 is an immigrant visa petition. But if you were not married when the I-140 was filed, then the answer to her DS form is no. Nobody has ever filed for an immigrant visa. Okay. But this is not a big deal. This is not a ground for denial of an H4, so don't worry about it. Next question is Geo 2008 applied for EB1B, waiting for approval of I-485 since September 2014. Something is wrong. It shouldn't be. Oh, September 2014. I'm sorry, I was reading 2011. 2014. Okay, well that's not a big problem. I've heard from prospective employers for a potential suitable position. They're willing to wait until I receive my green card next couple of months. Oh, I see. So your problem is my green card is still pending. Is it okay for me to send my resume out? And does it create a problem because I don't have the intention to take the job indefinitely? I think it should be okay. And as I recall, I hope I'm not wrong about this, as I recall, EB AC-21 does apply to outstanding researchers. It's not available for extraordinary ability aliens, but it is available for outstanding researchers and professors. Don't quote me on this. I'm 80% sure I'm right. Have this confirmed by our lawyers. So AC-21 will then protect you September, October, November, December, January, February, March. In March, you will have 180 days. So next month you could change jobs anyway. So sending your resume in, I don't see it as a problem. Okay. Tanex says, I got married in India a few years back. I'm in USA, F1 OPT. Divorced from wife, separated. Now, if I get married again, would this be a problem? And the answer is no. The answer is no. So if your wife is on F2 and then you get divorced and then you get married again and bring somebody else on F2, that shouldn't be a problem. No issue. Okay. Banyan Tree says, there's a question on Form I-140 Part 4, Question 6. Immigrant visa filed on your behalf? My employer answered no. In fact, it was filed, but denied by USCIS. Yeah. The question is, should we amend this case? It was approved with that incorrect answer. This is a difficult question to answer. On the one hand, it's really not that big a deal. On the other, I don't think we should take any chances. I think one good way to do this would be perhaps to open a service request, try to find this information. Do I need to file an amendment? There is this small error. Keep documentation of your efforts to correct the situation. Your employer will probably have to do that. And if USCIS is not able to satisfactorily respond to you, open an ombudsman's request. Try to get this answer through them. If you get the answer, great. If not, contact me again. Let's get back again together on this call and let's see what we want to do next. But I hate to file an amendment for such a small issue, but at the same time, I don't want to sit on this issue. I don't want to make it seem like we spotted the issue, then we did nothing about it. Okay. Your next question is, USCIS has raised an RFE for my visa extension for incomplete LCA, employer-employee relationship. Employer is now responding. What will be the impact of the visa extension if the RFE is denied? Will I be able to switch to another employer in the meantime? Well, let's look at the worst case scenario. So your H1 is denied. Can you go to another employer? As long as your I-140 is not revoked, you can use that I-140 to get another 3-year or at least the remaining period extension for another employer and then start a new green card. If the I-140 does not get revoked by USCIS for fraud or misrepresentation, you will carry your priority date with you wherever you go. Okay, so that's your situation. Next question is V. Kaushik 21. He's a lead mechanical engineer. I-140 was approved. Now I finished my MBA from a top school and want to go into management. 6 years of H-1B expires May 15th this year. I've got an extension, but they're not providing me with a copy of the I-140. Well, first thing you do is go ahead and put in a request under Freedom of Information Act / Privacy Act request from USCIS to get you a copy of all your paperwork. Oh, there's a raised hand. I'm going to get to all the questions at the end, so please stand by. I answer all the questions, and then I will invite follow-up questions on whatever we have discussed. Once we are done with all those, then we'll start new questions. So if your question is a new question, it must wait till the very end. If it is a follow-up question, it must wait till I finish answering all the posted questions. So first thing I want you to do, Mr. Kaushik or Ms. Kaushik, is to apply for Freedom of Information Act information from USCIS. If you Google, or I don't know Yahoo, but I Googled it myself just a second ago. If you Google USCIS space Freedom of Information Act, the page opens up where it tells you how to file a Freedom of Information Act / PA or Privacy Act request. Many times people have been able to successfully get a copy of their I-140 approval this way. Okay, and the interesting thing is you don't really need a copy of the I-140 approval many times. We can get H1 extension as well as the priority date transfer based upon your name and the employer's name by itself. Okay, and the fact that you are changing from engineering to management consulting should not be a problem. Okay. As far as what are the circumstances under which a company can deny sharing the I-140 information with the employee, there's no law on this. So employers can pretty much get away with murder if they want. It really is a difficult situation for employees to be in. That's why I'm saying file your Freedom of Information Act request. It takes a few weeks to process. It doesn't cost you anything. It doesn't take any fees. Might as well do it. You might be able to get a copy of your I-140 approval. S. Gupta 0607 received an NOID on approved I-140. So there's a notice of intent to deny. I think what you mean is notice of intent to revoke. Deny is when the case is still pending. If it's already approved, it's an NOIR. I'm in the 7th year of my H-1B. Now, first of all, if your case does in fact get revoked, you can file an appeal against the revocation, or your employer can. While the appeal is pending, you can get another H-1 extension. No problem at all. Okay. So can you apply for a new I-140 using the old PERM? I don't know. That depends upon the ground of revocation of the I-140. If the I-140 was revoked for something minor, or like something like ability to pay wages, you can try filing the I-140 again. The PERM remains good even past 180 days. When a case has already been filed, like in your case, you can use the same PERM. No problem. Can I transfer to another employer? As long as the I-140 is not revoked, file H1 premium processing, you should be able to transfer to another employer. Can I travel to India and go for visa stamping? Don't do that. It takes time. By that time, your case might be revoked. I would not do it if I were you. Kumar 2015 got I-140 approved with the current employer working at in-house project in Pennsylvania. He wants to move to Florida or Texas. What do I have to do? What does the employer have to do? You have to do an H-1B amendment, obviously. Okay. So H-1B amendment will have to be done. Does it create problems for your 485? Well, I don't know how long Have you filed an I-45? I guess not. As long as you are willing to relocate back to Pennsylvania upon approval of the green card, your 485 can be filed. And it gets a little complicated at that point of time. I would want you to talk to your lawyer, but I'm suggesting that that's certainly a possibility. So under certain circumstances, most important being your intention to join back the Pennsylvania job upon approval of the green card, you can file 485, even though you are currently working in Florida or Texas. Okay, but this should not be a problem for the H-1B visa stamping, especially if you file the amendment. S.K. Ramani says, I have a green card since 2008. I'm a student in India. I've got my reentry permit good till October 2015 because he was told by US Customs and Border Protection Service, CBP, that they'll take away his green card. So he got the reentry permit, which is good till October 15th. He wants to visit USA in March for 2 weeks. Can I do that? Does that create any problems for the validity of the permit? No, no problem at all. I'm pretty sure you can double check this. Your re-entry permit should be a multiple entry document. If it is a multiple entry document, you can come as many times as you like till September, October 2015. Okay, so entering in February or March for 2 weeks or 10 weeks creates no implications for the permit. Feel free to do so. Jay Abdul came to H-1B in 2008, got extension 3 months before H-1B expired, but it took 14 months to decide my case. Okay. Lawyer said, oh, everything will be okay, but then you realized H-1B got denied, appeal also denied, that you are now in unlawful presence. Jed, this is a very, very complicated situation. There's not much I can tell you. Even if you go under DAPA, DAPA, that does not give you the right to file 485. Once you've got that 1 year of unlawful presence, you are stuck with the 10-year bar. The only waiver of the 10-year bar is if there is some extreme hardship to your US born relatives or US citizen or green card holding relatives. I think they include children. I don't remember, does the waiver include children or not? There's some problem with the waiver, I know that. But if you have US born children like you do, if you can demonstrate some extreme and exceptional hardship to them, you might be able to get a waiver of the bar. Okay, so you should have somebody look at your case from both the perspective of whether the bar is applicable on you, two, if there's any way to retroactively or nunc-pro-tunc get you back into H-1B status, and three, the possibility of a waiver if the first two don't work out. Okay. So next question is from Zap0Paz. Something has been bugging him for a while. So what happened was, fiance is admitted to a well-known university. She came to USA in 2013 on tourist visa. At that time, she said she was his fiancée. Okay, even though there were no wedding plans, etc. On her F1 application, I believe it's pending now, she has identified me as an immediate relative, as now we are. So I'm assuming that you guys got married. I am LPR since 2009. Any particular reason why you haven't applied for naturalization? Because 2009 means you're eligible for naturalization now. So you should get naturalization. That will make her green card quite easy. Okay. So she's got money in her bank accounts, parents are alive. So what steps should she take? Now you're talking about student visa, I assume. How can we get her visa approved? Well, that's absolutely, the approval of a tourist visa or a student visa is a discretionary matter. It depends completely upon the consular officer. You can't really do much about it. Okay. What kind of documents should we collect to prove her intention to return? Well, you really can't do much about that. You can take that she does not own any property, you really can't do much about it. I think the strongest thing that is going for you is in 2013, she came to USA and then she left after spending less than 2 weeks. That kind of shows the consulate that here's a person who's not misused a visa in the past. I think that's your strongest ground. But the negative thing is that she's got her husband in USA. So impossible for me to answer. I think you should keep in mind in the interview, this question will come up. How do we know you're going to come back? And the answer is, if the law does not permit me to stay, there is no way I'm going to stay back. I will come back. So other than that, I have no interview tips. I only recommend to people, make sure you do not say anything which is not true, because if any untruths are uttered and they are misrepresentation or fraud type untruths, they can cause a permanent bar from entering USA, which is quite difficult to get waived. So, okay, next question. J1 visa holder, subject to 2-year home residency requirement. Can I apply for I-140 based upon NIW? Yes, yes. That's what we do. The J1 212E requirement seems to not foreclose I-140. It forecloses I-485. So that's what we have been doing. So far, we've never had a problem. So go ahead, try it out. Indeep wants to say, I've done my master's in IT management. I'm on STEM. Completed 29 months of OPT. Unemployed for 45 to 60 days. Well, I think you're allowed a total of 120 days. When you have 12 plus 17 months extension. So that is not a problem. Do I come under cap? I think so. I think so. Let's see. Oh, no. You are, after completing my 29 months of OPT extension with expiration on March 24th. See, if your 17 months expire on March 24th, which is before April 1st, my understanding is cap does not allow you to work, but it allows you to, because it's within 60 days of expiration April 1st, you can stay in USA and wait for the outcome of the H1, but you can't work. Are there any benefits if I remain on F1? No, other than staying in USA. Should I get it H4? Can I travel on H4? This is a difficult question to answer. Let me see. If you transfer to H4, then in order for you to get back onto H1, you have to apply for change of status or visa stamping. So out of these two choices, what I would do is, I would stay on F1, apply for the H1, see if I get selected in the lottery. If I do get selected in the lottery, no problems. Wait it out, get your H1, and travel after that. Second choice is, you're selected in the lottery, go get your H4 visa stamping and travel on that. But when you come back before October 1st, you'll have to apply for change of status back to H1. Okay, that's the way it will work. Next question is AB5. I'm on H1, good till 2018. I-140 approved under EB3. 3 years of Bachelor of Commerce, 2 years of postgraduate diploma in management. Graduate degree was a requirement for the PGDM course. So wants to move to EB2. I think first thing you need to do is get your diploma and degree evaluated. If the diploma indeed under the database accepted by USCIS, which is the Accra Edge database, if it lists that diploma as equivalent to a bachelor's degree combined with a 3-year bachelor's, then it's certainly worth a shot. Okay. It's got to be done under Accra Edge criteria. See, single source degree rule does not apply to EB2 cases. If you file under EB3, your 3+2 or 3+1 will not be recognized. But if you apply under BS+5 EB2, you can have more than one degree, and single source degree does not apply. If I were you, I would look for a draft of the PERM application in such a way that even if for some reason my EB2 is denied, EB3 survives. Even though you have an approved I-140, well, that's not really a criterion. So it's difficult for me to make this determination for you. Really, the entire crux of your case is based upon whether or not your degrees and diplomas evaluate equivalent to a US bachelor's degree under Accra Edge standards. Okay, that is correct, Ashish. Whether or not you qualify for EB2 and the value of your degree is only evaluated really at the I-140 stage. Yes, and we do draft EB2s in these circumstances in such a way that if the EB2 gets declined, EB3 should be approved. PVNP says, I'm a permanent resident. I'm getting a re-entry permit. Is it mandatory to use the permit once obtained? Of course not. You can choose not to use it. Can I travel to US multiple times while it's valid? The answer is yes. Typically, when you apply for a re-entry permit, I think there's an entry on the form that says, do I want re-entry permit for multiple entries? And it's the same fees. Why would you not want it for multiple entries? So the default is multiple entry. Double check if in doubt. Okay. Next question is Rahul. PERM and I-140 approved by employer A, currently on extended H-1B based upon I-140 approval. I want to change my jobs to B. Is there a minimum period that I should wait before changing jobs after I-140 approval? No, there is none. What do I need? Okay, keep your I-140 approval. That's the most important thing. Keep your I-140 approval. I think it's a good idea to have a copy of the PERM as well. But at the very minimum, keep the I-140 approval. That would be a good idea. Also, when you apply for H1 transfer over to another employer, don't move until the transfer is actually approved. File it premium processing. Murali Krishna says, I worked 2 years in a reputed software company. Visa expires in June 2016. Total experience is 10 years. Everything is recaptured. Can I apply for EB1 because I'm in delivery manager designation? If you're thinking of EB1C, EB1C is only available if you work for a branch, parent, sister company of this company that you're working for outside USA for 1 year. PERM, how long it takes? EB2, EB3, time for the PERM is the same. Time for green card is different. My advice would be to file PERM as quickly as possible, because once the PERM is filed, on the first anniversary of the PERM filing, you are entitled to 1 year extension. If by good fortune PERM is approved before then, you can file I-140 premium processing. I-140 approval will give you 3-year extension, regardless of when the PERM was filed. So PERM anniversary of 1 year gives you 1 year extension of H1 ongoing. I-140 approval, regardless of when it is approved, 1 year or before 1 year, doesn't matter. I-140 approval gets you recurring 3-year extensions. File PERM as quickly as possible. Harsh, spouse has I-140 approved Jan 2011 priority date from ex-employer. Change the job. New company is in the process to file a PERM. I spent 2 years on H4, currently working with company on H1, completing 6 years in December 2015. Well, you can switch back to H4, because even if you have exhausted 6 years of H1, you are allowed to switch back to H4, because H4 period is not counted in that 6 years. Okay. And let's see. S. Santhra says, got my PhD from USA, worked from October 2007 to June 2012, which is what, about 4.5 years. 4 years and 9 months. Do I need to apply for a fresh H-1B on April 1st? I think, like I've said this several times today, I think you should be cap exempt if you are willing to take the time remaining on your H1. If you want full 6 years of H1, then you have to be subject to the quota. Okay. Next question is Sunil Benjamin for his brother. His brother was in a degree on speech language pathology, and he got into an accident during his OPT, a very bad accident. It sounds terrible. Hospitalized for 3 months. But he needs at least 3 more months to get back to his work. His OPT is good till May 2015 only. But he can't complete his clinical fellowship to become a professional pathologist. Can we extend his OPT? And the answer is, I don't know of any way to do that. You can double check with the school's designated school official, DSO. I don't know of any way to extend this even on a medical ground. I can't recall any regulation that allows it. So looking at H1 or perhaps going back to school and getting a CPT of some kind, those might be the only options. I don't see what else he can do, Sunil. If it is an unpaid internship, he can try doing it on B1. That might be a good idea on a tourist/business visa. Explain to USCIS what happened, and if it is an unpaid fellowship, you might be able to finish it on his on a tourist visa. Okay, and the thing is, once you file for the tourist visa, start your internship or fellowship. By the time they decide the case, your 3 months or 4 months are over. I don't know how much time you need. I don't know how much time you need, Sunil. I hope you're on the phone. I hope I can talk with you. Let's talk about this if you're here. Because if you just need a few more months, it takes USCIS 4 or 5 months just to rule on the B1, B2 application. That may be a good way to go. Last question of the day, posted question is from Braham AG, okay, or Brahmaji, I guess. Okay, it says there's a new directive from USCIS about non-IT background people getting screened extra carefully for H1B. No, not really. The fact of the matter is H1Bs always require careful scrutiny, whether you are IT or non-IT. Sometimes the cases might slip through, but most times USCIS very carefully makes sure that the job requires a degree. Today I was finalizing a case for an RFE for somebody. They have a degree in bioinformatics, and they are developing front end and back end. So the user GUI as well as the business logic for databases that track spread of diseases. So for this person, having a degree in computer science is not enough. You need a background in biology as well. So I think in cases like that, it's legitimate to claim that we want a degree that impinges upon both areas, computer science as well as biology. Okay, we have many cases. Marketing is one case, economics is another area, international relations is another area. So there are all kinds of bachelor's degrees. As long as the job requires that bachelor's degree, you'll be okay. All right, folks, I'm going to answer only follow-up questions on posted questions. If you posted a question and you have a follow-up question on your posted question, press *5. Once I'm done answering these, we'll start with all new questions. So I have only 2 people who have follow-up questions. Let's start with Pennsylvania. Go ahead, please. Pennsylvania, I can hear you. Scranton.
Hi,
Hi, Rajiv ji. This is for the question number 9.
9. 1 second. Let me get to that question.
Okay. This is for moving from Pennsylvania state to a new state, Florida, Texas.
Yes, I remember your case. Go ahead. What is the question?
Okay. I understand that if I need to go, I need to do H1B amendment, correct?
Correct.
Okay. But if I don't want to do like that, and for example, if my I-485 becomes current, after filing my 485, can I go from Pennsylvania state to Texas or Florida if I want, or do I need to wait for anything else?
Well, your question actually requires a fairly lengthy discussion. I can give you bottom lines, but we don't have time to go over all the analysis that goes behind the bottom lines. So bottom line number 1, you actually don't have to wait after filing 485 as long as one of the two things exists. 1, 180 days pass uneventfully, USCIS doesn't question it. If you have already moved, no problem. So condition number 1, if 180 days pass without any questions asked, your 485 is already pending, you're safe. Okay. Second condition, if you get an RFE in the first month or second month after having moved, as long as you can say in good faith, hey, I intend to go back when my green card is approved, the 485 will continue, and after 180 days of the pendency, you are safe again. So the funny thing is, you just have to have the intention and you are safe. After 180 days, you become safe. Before 180 days, your intention can save you. Okay?
Okay. I have one more question.
Go ahead.
For example, if I'm planning to do H1B amendment and if I want to go, what is the location address I need to give at the new place? Because in the new place, my employer doesn't have any work location. So do I need to give my apartment address as my location?
Let your lawyers handle it. I can tell you what I would do. I don't know what your lawyers want to do. Typically, in cases like this, I file from your home address, showing that to be the place of employment. But the LCA posting I do at your employer's site because that's where the work is going. Okay? Let your lawyers handle it. It's not a difficult situation to handle.
All right. Thank you very much for your help.
You're welcome. Good luck.
Thank you.
Okay. So we have only one more question, follow-up question, then we'll start with new questions if there are any. Connecticut, go ahead please, Connecticut.
Hi, this is Teja with reference to question number 10.
10.
So my question is, suppose we file H4 and then EAD rule comes out. Do you think we can file EAD with the receipt of H4 filing before it gets approved?
See, Teja ji, we don't have that amount of information. That's a very fine-grained information question. My guess would be, based upon how we handle L2 EADs, yes, we should be able to. But do I have concrete information on that? I do not.
Understood.
All right.
And the second question, did you hear anything like, will there be any restriction on the amount of EADs they're gonna give out for H4?
They cannot. No, at this stage they cannot do that. Look, once the government publishes a regulation, they can't change that regulation. If they want to change the regulation, I mean, they can't change it beyond the comments that they have received. If they want to change it in such a fundamental way as to limit the number of EADs, I think they'll have to publish it again. So to the best of my knowledge, and I don't remember all of my administrative law that deals with regulation publications, but I think it's illegal for the government to change a regulation without offering it for public comment again. So to answer your question, under the form of regulations that we saw, there was no limit to number of H4s.
Perfect. That answers my question. Thank you very much, Rajiv.
Good luck, sir. Okay, in the meantime, we have received one more question. You know what I'd love to see? There are people from every state here. I've got New Jersey, New York, California, Connecticut, Florida, Illinois. It's amazing. I mean, how connected we all are. It's great to see that. Okay, California. Go ahead. I can hear you. California.
Hi, Rajiv ji.
Hello, sir.
This is regarding question number 5.
5. 1 second. 5, 5, 5. 5 says F1, getting divorced, want to get married again on F2. Is there any problem? The answer is no. Yeah, go ahead.
It's not the one after there. That
Oh,
one.
so you're not getting divorced. You're sure about that?
Yeah, the banyan tree.
Okay, 1 second. Question number 6, right? Banyan tree?
Yes.
Okay, 1 second. EB2 I-140 based upon US master's degree. Oh yeah, the employer forgot to mention that there was an I-140 485 previously filed, right?
Yep.
Okay, I don't think this is a big deal, but we should still make the efforts to correct the record.
Okay. Okay.
And the best way to do it is to at least start what I told you. If you listen to the recording, I'll probably have the recording up in by tomorrow for sure. You know, you can at least make some efforts to find out what you should be doing. I think it's an inconsequential little issue, but hey, let's just make our efforts to correct it. Okay?
Okay. Okay.
Anything else?
Yeah, sure. Yeah, because as the employer has to do it, right? Personally, I have to do it.
Right. And if the employer declines to do it, then you call the USCIS and you let them know, and this is the situation, what can you as an employee do? If they don't give you a satisfactory answer, open a case with the Ombudsman's office. That shows your good faith.
Okay, good.
All right?
Okay. Because they didn't provide me the I-140 copy. I got it for a year, so I need to contact.
Yeah, that's okay. I mean, try your best. If you can't get it done, I don't think it's a big problem.
Okay. Okay.
All right? Good luck.
Yeah. Thank you.
Okay, guys. Anybody has any question, press *5 on your phone. 1. *5. What? 2. Okay, I was surprised. Only 1 question. 1 person. 2. Even that means you guys already know all the law. Excellent. Now I can retire. Okay. New Jersey. Go ahead with your question, please. New Jersey. We can hear you, New Jersey. Go ahead. All right. Let's try New York. New York, go ahead.
Hi, Rajiv ji. Thank you for your help, first of all. And my question is about my situation that I've done my master's and wasn't able to get a job. I did my master's in curriculum development in instructional technology, so it's related to education, and I am unable to find a job here in any category, EV 1, 2, or 3. So since it's been about 10 years now that way I'm here, I had H1 twice with a private school, with 2 private schools, but they were not able to file my green card for some reason, for their own reason.
Okay.
Do I have any other option, like getting a hardship or something? Any other way that I can get a, I don't want to pay F1 fee for the rest of my life.
As of this moment, there is no option. Just because you have lived here for 10 years, or because you are in education, or because you don't have an employer, none of these circumstances open up a gate for a green card.
Okay. So my best bet would be staying in school?
If you want to stay in USA, that would be one option.
Right.
That would be one option, sure.
Another option?
Well, I don't know. If you are in love with a U.S. citizen, that would be nice.
Okay. And my other question was, if I have my degree in, I get my degree in marketing, which I'm working towards, and some company hires me with like a taxi company or something to manage their business and develop their business and work on that. Do you think my H1 would be fine with that since I have the other education related degree?
You see,
Should I be able to get that?
ma'am, the fact that you have degrees in more than one field is not a problem for you to choose one field to focus on. Okay, let me give you my own example. My first degree is in biology and chemistry. Okay, then I went into law. If I wanted to go and get an H1 for my degrees in biology and chemistry, it's no problem at all. I can do that. So as long as your degree has been completed and it's a 4-year degree, there is no problem taking recourse to and applying an H1 under that degree. Now, I would warn you, marketing H1s are notoriously difficult to get. We do them all the time, but make sure your lawyers look at the facts. Make sure the lawyers compare your education to the job. Make sure the employer is big enough to require a person with a marketing degree to work for them. All these things being said, the fact that you have multiple degrees is no problem. Okay?
Okay. So if I get to get a strong job description from my lawyer or from you, do you think my chances would be greater to get a H1
Well,
and further green card?
ma'am, the most important thing to remember is we can only work with the facts. We cannot make things up. These papers are filed under penalty of perjury. Everything must be done completely truthfully. And if we are all working with facts, I am not a magician. All I can do is present the case in the best manner possible. I cannot improve your chances drastically. In presentation, our office can probably make things better for you 10, 20, 30%, but we can't change it 100%. So if you ask me, can I make your case better? The answer is probably, depending upon the facts of the case. Can another lawyer do it? Sure. Anybody can do it if they pay attention to it and if they have the experience. Anybody can do it. So, yeah, you can file a green card under the same category depending upon your resume and your case. I do not know all the details, but theoretically, at least, all of this is possible.
No, I understand that everything should be truthfully done. But the only thing that I'm lacking probably is going to be the experience because I haven't worked as that, position on that position before.
One of the
So
things,
if I don't put experience,
one of the things you could do is, let's say you join this employer on an H1. H1 doesn't require experience; it only requires a degree. Okay. After 1 or 2 years, you can either do a green card for a promoted position in the future or change employers. That way you can use the experience that you have gained working with the current employer.
okay, and that should increase the chances.
Of course, of course.
But do you think it has the potential of getting the, visa properly?
Definitely.
I mean,
Definitely. I think there's a potential. Again, I said theoretically because I don't know the facts. But if somebody came to me and said, I have a degree in marketing, a degree in education or curriculum, development, and can I just choose to go marketing? And the answer is sure. Can I also get a green card under that? Sure. I don't have any experience. Can I use the experience I gained with the current employer to go for a higher job with the same employer or a totally different employer? Yes, of course. All of that is possible.
and also, do you think that if I get my H done and I try to apply for green card for the next step, do you think I need to have a better job description? I need to request my employer to give me more responsibilities, or
Well,
that
is a difficult question to answer. What you're asking me is a very, very lengthy discussion. I have told you already the bottom line that all of this is theoretically possible. You can use the experience gained while working for an employer only in one of the two circumstances. If you want to apply for a green card through the same employer, they have to offer you a job that is quite different from the one that you were doing. That can be a future job. Or you can take the experience that you've gained and go to another employer and they can use that experience. Okay, I gotta go on. But this is all theoretically possible. Don't give up. Okay?
Okay, thank you very much.
You're welcome. You're welcome. Good luck to you.
Thank you. Bye-bye.
Bye-bye. Okay, I had a raised hand from New Jersey, but they never spoke. New Jersey, you still have your hand up. Woodbridge, New Jersey.
Hi, Rajiv, sir. Can you hear me?
Yes, yes, of course. I can hear you fine.
Okay. This question is regarding my wife's job situation. She entered the US on H4 visa. In last 3 months, she got a job, got converted to H1, worked for an investment bank for 3 months. Now she lost the job and we want her to go back to H4. It's been around 15 to 18 days that she has lost the project. I need to know whether she's out of status and whether there would be any issues in getting her back on H4.
Once she stops getting paid, she's out of status. Okay? Once you're out of status, your best bet is to go get H4 visa stamping done and come back again.
Okay. And the second question would be if, say, for example, she files for an H4 today, when will she be considered to be on H4 from today?
No, from the date the H4 is approved. I am strongly recommending do not consider applying for H4 from here. It's too risky a gamble. Let her go to India, get her visa stamping done and come back.
She already has an H4 stamp already.
Well, I was hoping you will say that because then it makes it possible for me to tell you about the beautiful section 222G. 222G says if you have been out of status for even 1 day, we consider your visa to be cancelled.
Okay. The issue here is, Rajiv, that employer did not inform her. I mean, they informed her today that they would be cancelling her. They would be firing her from in the past days that she has been already fired. That is what the situation is. They never told us that she's fired.
Hang on 1 second. You said the employer told her today?
Yes.
Okay, well, that changes things. What you can do is file her H4 today, right now, online. At the same time, and I'm assuming she's been working all this time, right? She was working all this time?
She was employed, but the project was over. The project got over last month.
Okay, hang on. I think we can help her. What you do is file for her change of status today. Okay, form I-539 online. In the meantime, file a complaint with the Wage and Hour Division of the Department of Labor that she is owed a salary all the way on her H1. Remember, employer cannot bench employees. Okay? What does that do? By filing the complaint, she has done two things. She has shown that she was available to work and the employer did not give her work. That puts her back into status, in my opinion.
Okay.
Now, keep track of 180 days or maybe even 150 days from today. Okay. If she has not received her H4 approval with I-94 in 150 days, call me back.
Sure. And in the meantime, if she transfers, if she gets a project in between, can we withdraw the H4 change of status?
Yes. My recommendation would be to withdraw the H4 only, file the H1 premium processing, withdraw the H4 only when the H1 is approved with the I-94.
she already is.
No,
on
but when
H1,
she goes to another employer, she needs to transfer the H1, doesn't she?
No, but if the same employer asks her to continue on a different project,
As long as they pay her for all the period that they kept her on bench, I see no problem with withdrawing the H1.
okay. And how much time does it take for the transfer? I mean, from
I
H4
can't.
to H1 or H1?
I cannot tell you that. It depends upon the too many variables.
Okay. Last question. Would it be advisable to go for filing H4 ourselves, or should we do it by an attorney?
I prefer that you get a lawyer. You can do it yourself, but really you don't have enough time. If you ask me to do it today, I don't have time. There's no way I can do it today. So I think you have no choice because she was told today that she's getting laid off. Go ahead and file the I-539. If there is an RFE, then get a lawyer.
Okay. And I-539 can be filled online for H4.
That is correct.
Sure. Thank you very much, Rajiv, sir.
You're welcome, sir. Good luck to you. Guys, as always, it's a great pleasure to talk with all of you. And I will see you next Thursday. Thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.